All right, welcome back to another National Real Estate Exam Prep. And today we're going to talk about real estate contract law. Now, this is a big piece of your national exam. And so it's going to go over a variety of different concepts that need to be dialed. And I do believe that the tighter these things get as far as conceptually goes for you, you're going to have an easier time with your exam across the other chapters as well. So let's jump into this thing and let's talk about the types of contracts and the validity of them and the enforceability. So the very first thing we have is a valid contract. Now, a valid contract is one that meets all legal requirements for validity. And we're going to talk about those here in the next section. But what we're looking at is a valid contract must be in writing to be enforceable within a statutory period of time. All right, so a lot of moving pieces, right? So we have a valid contract, it needs to be in writing so that it can be enforced, and it must be in the statutory period of time. And the statutory period of time is going to allude to an unenforceable contract that we'll talk about here soon. Also, a valid contract made orally is generally enforceable within the statutory period of time with some exceptions. All right. So I think the biggest thing that we need to keep in mind here for a valid contract has all the legal requirements that a contract must have. That's what makes a contract valid. Now, when we're talking about valid but unenforceable, we know that there are most contracts, when we're talking about real estate specifically, most of our contracts are only enforceable if they are in writing. And this applies especially to transfer of interest in real estate, right? When we're talking about the contract to buy and sell, when we are actually talking about when the buyer and the seller come together and they put together a contract and then we're doing deeds, like these must be in writing to be enforceable. Now, we do know that there are oral contracts, and an oral contract, it does meet all the legal criteria for the validity piece of stuff, yet it may not be enforceable. All right. So, when we're talking about the statute of frauds, which we'll talk about here in a moment, the statute of frauds says for a contract to be enforceable, it must be in writing. Now, when we're talking about contracts that are valid but unenforceable, an oral long term lease, yeah, it has all the components, right? Like we're going through and the tenant is giving money for the lease. The landlord is going through and allowing the tenant to live in the premises. Yet when we're going through and we're looking at this thing, it might not be enforceable if it goes in front of a jury of your peers. And that's where a lot of this comes down to it, is a jury of your peers. And that's why we talk about even writing contracts, and we can't be ambiguous on how we write contracts, because if it comes down to it and party A doesn't know what party B was trying to say, and maybe party B can't even articulate what they were trying to say, then it comes down to the rule of law. Also, an oral real estate sales contract, right? When we're talking about the contract to buy and sell, it's going to be very hard to enforce a contract of that magnitude and say, well, this is what we intended to do. That's why everything that we're doing when we talk about the statute of frauds, the statute of frauds says for it to be enforceable, it must be in writing. And now, if a contract is valid but unenforceable, it still remains valid, right? So when we're thinking about this, if both parties fully execute it, well, it's going to be very hard to actually alter the outcome. You know, like if someone goes through, and let's just say that you have an agency agreement, for example, you have an agency agreement that you did not get signed, right? You went through, you were going to represent the buyer. You and the buyer went through, you did all the steps. You went through, you were showing houses. You helped them put together the contract to buy and sell so they can go buy a house. You sat at the closing table with them and got them to the finish line. Well, everything happened, right? You performed. Both parties, the seller sold the house to your client. You represented your client. You did not have an agency agreement in place. And so at the end of the day, after you potentially get paid by the seller, you can't go back on everything. They can't say, well, hey, we didn't have an agency agreement, so I would like to have the commission check back. That's what we're saying, when it's going to be very hard to alter those outcomes. But it brings us to this thing called a void contract. All right. So we talked about valid, we talked about valid yet unenforceable. Well, let's talk about void. A void contract fails to actually meet one of the legal requirements for the validity of a contract. And since that happens, since one of the legal components is missing, which makes it void, it doesn't qualify as a contract. You never had a contract in place to begin with, since you missed one of the legal components that makes a contract valid. Full stop. Like, that's what this looks like. So on your test, if you have a test question and it's talking about you didn't have a meeting of the minds, you had incompetent parties, well, then the contract's void. It's a void contract. Neither party can enforce it. So when we're going through and we're looking at this thing, an example would be a contract without consideration would be void. Right? Let's talk about the contract to buy and sell, or let's talk about an agency agreement. The agency agreement, let's talk about the sell side of things. You have an exclusive right, you have a seller agency agreement, and the seller says, hey, agent, if you sell my house, you will be entitled to a commission. So we're saying if we have an agency agreement and there is nothing in it, right? So we have an agency agreement and the agreement doesn't say that, hey, we're selling a house and that there is no monetary gain at the end of this. Well, then we have a void contract. We are missing consideration. Also, if it's for an illegal purpose, right? And we put this in here, so extorting money from a business would be void. For the most part, when we're talking about real estate, we're not going to really run into a whole lot of illegal purpose for real estate. And I guess it could show up. Another thing that we could see is null and void, which just means that the contract is void. That's all it is. It's null and void. So void contracts are missing one of the legal components that makes it a valid contract. Now, let's make it a little bit harder. Let's talk about a voidable contract. And this is where you're going to have to put your thinking hats on your test. Okay. So if you get a test question, and keep in mind, these companies, they're for-profit companies. They want you to pay them as many times as possible. This is the barrier to entry. You went through real estate school, you got your Rec 33, and now you're sitting down and you're taking the test. This is literally the last step before you can go affiliate with a brokerage. And this company knows it. So they're going to put test questions in there that are going to challenge you and trip you up. And I think one of these questions is going to be around a voidable contract. And a voidable contract actually looks valid. So everything on the surface looks good. We went through, we did all the check boxes, and we feel like we have a solid contract. Yet we go down through the process, and one party rescinds the contract for a legal reason. Now, here's the thing that we need to keep in mind. It's only the affected party. All right. Only the affected party can void the contract. And so what I mean by that, and I have a bullet point for you, but let's just say one party lied to the other party. All right. So we know, we go through and that we have to disclose material facts. We must disclose any adverse material facts to the other party. And let's just say the seller knows that there is an issue with their home, and an issue that if the buyer found out, the buyer would probably not go through with the contract. Now, we're going through our due diligence phase, right? For our concessions, we're doing our inspection. And as we're going through the inspection, the buyer notices what the seller failed to disclose. The seller doesn't get to just raise their hand and say, "Hey, I failed to disclose that. Let's just cancel this contract and walk away." It's the buyer's sole and subjective discretion with what they do from there. The buyer could say, "You know what? This is a great deal that I'm getting on this house. I love the house still. I love the location. Yes, this issue, not ideal. Yet, I've got such a great deal on this home. I'm going to take it with this now known adverse material fact." So it was voidable if the buyer raised their hand and said, "Let's void this thing." Yet, if the buyer wants to go forward, they can go forward. It is to their sole and subjective discretion with what they do with that information now. So the affected party, and we know that the disaffirmation must occur within a legal time frame for it to be valid, right? So we're really just talking about the statute of limitations. Maybe we're talking about inside of the contract, right? And the contract will most likely actually say what happens if you find out down the road after your contingency dates have passed. Yeah, that's a conversation for a different day. If the affected party does choose to proceed with the contract, instead of rescinding it, the contract becomes valid again. All right. So it was voidable. Voidable, the party affected gets to raise their hand, not the party that affected them. Now, when we're talking about void and voidable, a void contract is never enforceable because the contract never existed. All right. If you have a void contract, it can never be enforceable because the contract never existed because you were missing a legal component. A voidable contract is enforceable unless the affected party takes action. And so a lot of you are probably thinking about maybe a minor at this point, right? And let's start thinking about some of these YouTubers. Let's start thinking about some of these 16-year-olds, 17-year-olds that have these YouTube channels. Maybe we're thinking about the Winter X Games, some of the snowboarders, like they have enough money to purchase a home. Now, with that being said, it's perfectly legal to sell a minor a home. With that being said, at any point during the transaction, if they feel like they have been taken advantage of because of their age, they can raise their hand because a contract with a minor is a voidable contract from the get-go. So at any point that they feel like they're being in a position to where they don't want to be, they can raise their hand and say, "Hey, I'm out," and they can void the contract. So those are going to be your only two situations on your exam when they're talking about a minor, someone that's under 18 years of age, and or an affected party that later down the road either does or does not raise their hand. That's where we have voidable contracts. So when we're talking about the validity of a contract, right? So the essential elements which make a contract valid. First and foremost, we have to have competent parties, right? We actually have to have the parties have the capacity to enter into a contract. And with that being said, it has to be at least two parties. Like you cannot enter into a contract with yourself. It doesn't work. You have to have party A and party B. We have to have a meeting of the minds, competent parties, they come together. When we're talking about this, there's three factors. There are three factors that go into place when we start thinking about the capacity for someone to contract. The first one is legal age. Again, we're talking about someone that's over the age of 18 years old. They have the mental competency to move forward and the legitimate authority. And so if you're looking at the legitimate authority, I would think of like POA, like the power of attorney. Like maybe they are standing in for somebody else and they are actually signing the name and moving that person forward. Minors, on some state exams, it might be void. And on some state exams, it might be voidable. Yet for the national, it's just a voidable contract. All right. So on your national side of your your test, it would be a voidable contract. Mental competency, when we go through, they have to understand the meaning and the consequences of the contract. Like that's what they're asking about. Like, does this person understand what happens through the process and at the end of the contract that we have? Competency is distinct from sanity. Those deemed incompetent cannot enter into enforceable contracts. Now, what we do know is a court ruling or other legal determination can establish incompetency, right? Like if it goes to court and the court says, hey, this person was incompetent, then we have a void contract. In some cases, convicted felons could also be considered incompetent depending on what crimes they have committed. And if a party is deemed incompetent, a court appointed guardian may actually act on their behalf with court approval, right? So we think about this like POA again, this power of attorney, like someone could actually be appointed to stand up for this person and proceed with the contract. Then what we're looking at is mutual consent. All right. So when we're talking about mutual consent, which is also known as offer and acceptance and or the meeting of the minds. All right, so it could be put either one of those three different ways on your exam. We have mutual consent, offer and acceptance, meeting of the minds. One party makes a clear and definite offer, right? We have the offerer. Historically speaking, this is the buyer. The buyer says, hey, Mr. and Mrs. Seller, I would like to purchase your property that you have listed on the MLS. The other party provides intentional, unqualified acceptance, right? So when we're talking about this, we have the offeree. Historically speaking, this is the seller. The seller says, hey, love the offer. With those terms, I would sell you my house. We have offer and acceptance. Now, again, we could see that a court nullifies this contract if it's partial, accidental, or vague. Again, like we need to understand that when we are writing contracts as real estate agents, and you could see something on your exam, that when we are going through and doing these things to make sure that we are putting our client in a position to win, that we are making sure that we are speaking at a language that a fifth grader can understand, yet that if we're putting language into the contract because we have the right to do that, that language is understandable by all parties and that is very clear. So there's your mutual consent, also known as offer and acceptance and or meeting of the minds. We also have to have valuable consideration. This is a two-way exchange. All right. We talk about this as a promise for a promise. A contract is invalid if only one party provides consideration. Now, we do know that a gift is perfectly legal, right? Like a family member, a parent could gift their kid a home, and that's perfectly legal. Yet, I would say that that might actually be voidable in some kind of instances, especially if we have a void contract, if they were gifting a home maybe for a tax shelter and or if it was for an illegal purpose. Because again, if it's anything for the purpose of defrauding the government, anything along those terms, it's no longer valid and or voidable. We have a void contract. So examples of your valuable consideration, most of us on this call, right, we're thinking about tangible money, property, goods, right? Like someone could trade a house for a house. That's consideration, perfectly legal. We have goods. We could be actually thinking about maybe cryptocurrency. I mean, someone could go ahead and trade livestock. Like all that is perfectly legal. Most of the time, we're going to be dealing in money as real estate agents. Also, when we go through and we look at this, we have promises to perform. We could also see where someone goes in and they put a contract on a new build. And the builder promises to build a house in exchange for payment. That would also be consideration. All right. So we need to have a two-way exchange. We also have to have a legal purpose. The contract purpose must be lawful. This is not John Wick. All right. In the grand scheme of things, all the contracts that you see in the John Wick movies, well, those are void. Now, I don't know how you get out of one of those contracts, yet those would all be void contracts. A contract for an illegal act is void. Full stop. Like, it doesn't matter. But then when we're going through and we're thinking about voluntary good faith agreements, they're freely and voluntarily in good faith. And what we mean by that is a contract is voidable. And again, here's voidable. So just to add a little bit more confusion, a contract is voidable if a party entered into a contract through duress, coercion, fraud, misrepresentation. And what I mean by that is here, let's talk about coercion. Let's think about like an elderly parent. All right. Elderly parent, they want to stay in their home, but their kid is forcing them to sell and is in their ear telling them it's time to sell. You need to get out. We could actually use the money. Think about your kids, right? And they're in the parent's ear, this elderly parent's ear. Well, if it never comes to light that conversation actually happened, like if that elderly parent never raised their hand and said that I was actually coerced by my child, well, then we have a valid contract. If that elderly parent raises their hand somewhere along the line and said, my child actually coerced me into selling my house, now we have a void contract. That's why those are voidable, because all those things could have happened, but yet if no one knows, then they're going to go forward. And misrepresentation, and here we go again. So when we just talked about a material defect, here's another example. If a seller falsely claims that a house has a new roof, yet the roof is actually 20 years old and it leaks, the buyer may rescind. They don't have to. And that's what you're going to have to know for your exam. Just because something is found out down the road does not automatically mean that the contract is void. It is at the sole discretion, the sole subjective discretion of the party affected. And in this case, it's the buyer. And a contract that conveys an interest in real estate must meet these following requirements. It must be in writing. Statute of frauds. It has a legal description. Remember, when we're talking about legal descriptions, meets and bounds, lot and block, geographical land survey, governmental survey. The property address is not a valid legal description. Also, I actually think that's going to be your test question. I think you actually do get a question that pops up on your exam that says, which one of these is not a valid legal description? And they're probably going to trade a governmental survey and a geographical land survey. Like, they're going to probably play with those a little bit. And they're most likely going to say property address. Property address is going to be your answer. Yet, you could also get like a tax ID, like a tax assessor's address, which looks a lot like meets and bounds. It's just a little bit different. I don't think that's the test question you're going to get, though. And it has to be signed by the parties. Now, here's your exemption, your exception to the rule. Your exception to the rule is this: leases for less than 1 year do not need to be in writing to be enforceable. I actually do believe this is going to be a test question as well. Leases for less than 1 year do not need to be in writing to be enforceable. Everything else does. Every other contract needs to be in writing to be enforceable. Now, when we're looking at the statute of limitations and the statute of frauds, the statute of limitations, we don't care about the actual time. For the national exam, it's going to be broad. They're not going to talk about it on your state exams, but for your national exam, it's a broad number because all states are differently. So Some contracts that fail to meet the validity requirements may still be voidable if the damaged party takes the appropriate legal action. All right. So, however, the enforcement of the voidable contract is restricted by the statute of limitations. Some valid contracts may not be enforceable due to the statute of frauds. Okay, cool. Like we understand that. For a contract to be enforceable, it must be in writing unless it's a year for at least for less than 1 year. And when we're talking about the statute of limitations, this is a time limit where the injured party can take action against the other party. Now, it's a statutory period of time. We're not going to worry about the statutory period of time, but this is where it pops up in my mind. I think of like a new build. All right, let's say you go and you contract on a new build, and one of the things that you were looking for was bright white kitchen cabinets. Right, that's in your contract. It's spelled out. Statute of frauds, check. It's in writing. Everything is perfectly legal. Yet you voice the concern to the builder. The builder says, hey, we screwed up. We put in off-white kitchen cabinets. And you're like, that's awful. I don't want that. I want my bright white kitchen cabinets. So they say, well, hey, work with us, take over the home. We will get it fixed. We're going to order it. It's coming from across the ocean. They'll be here. We'll get them installed. Now, we hit this time limit, all right, to where we're not saying it's like 30 days or 60 days. We're talking it's a pretty decent amount of time. Goes by and the cabinets were never reinstalled. And you still have your off-white kitchen cabinets. Because of the statute of limitations, you would no longer be allowed to take the builder to court to have the judge enforce your contract. That's the statute of limitations and how that pops up. So statute of frauds, we've talked about this a couple times. This keeps popping up, and I think it is important. It's very important for your exam to understand what the statute of frauds is. This is a requirement that certain contracts must be in writing to be enforceable. And when we're talking about real estate contracts and the statute of frauds, any contract that conveys an interest in real property must be in writing, with one exception. A lease of less than 1 year can be oral and still enforceable. All other real estate contracts, the contract to buy, to sell, to exchange, lease of interest in a property for over a year, all of those must be in writing to be enforceable. Now, most states, they have their listing agreements must also be in writing. Now, we know that like in Colorado, you have a transaction broker relationship. Well, that's not in writing. It doesn't have to be in writing. It could be in writing, but it doesn't have to. So most states, listing agreements must also be in writing. The statute of frauds and the contract validity looks like this. The statute of frauds affects the enforceability, but not the validity of a contract, right? Like you could have a full contract written, but if it's missing a legal component, it's a void contract. It's no longer valid. The statute of frauds just says that if the contract is valid, that it's enforceable because it is in writing. If the parties fully execute and perform a valid oral contract, even though it was technically unenforceable, you can't rescind it because of the statute of frauds. You can't say, well, hey, we actually didn't put that on paper and we want to walk away at this point. No, like it doesn't work. Like we've already have an executed contract. We've already gone from point A to point Z. We've made it to our destination and we expect it to be carried out the rest of the way. We're not going to go and rescind the contract at that point. So let's talk about offer and acceptance. When we're looking at offer and acceptance, an offer expresses the offeror's intention to enter into a contract with the offeree, agreeing to perform to the terms in exchange for the offeree's performance. Okay, cool. So we have offer, offeror, offeree. We know that in most cases, the offeror is the buyer. The offeree is the seller. Always, always, always. If you see OR, that is always the giver. EE is always the receiver. Every time on your test questions, when you're going through, you see OR, that is the person giving. You see EE, that is the person receiving. In a real estate or lease contract, we have to clearly contain all intended terms in writing, and they must be communicated to the offeree. So we're going through and we're saying, hey, this is what we're doing. The buyer, the offerer, wants to buy your house, Mr. and Mrs. Seller, the offeree. This is the dates. This is the money. This is everything that they want to offer to you in exchange for you giving them your home. It all must be in writing. If something is not in writing, it is not enforceable, guys. So here's the thing. If you get a test question that goes through and it's talking about how the buyer told their agent that they wanted all these things and yet the agent missed something, well, it's not a part of the contract. More so, the contract wasn't with the agent, the contract was with the seller. And so, if the agent missed a component to the contract that the buyer wanted, it's not a part of the contract. It's not part of the terms. The buyer can't walk away for those reasons unless they have a contingency for it. So they have literally written a contract that says, even though I told my agent one thing, we have a signed agreement for another, and that's still a valid contract. Now, if an offer includes an expiration date, and in most times it does, right? Contract for a year. In most cases, in most states, contract for a year in time is the most you can have. We have a definite start date and a definite end date. We have time is of the essence. All right. Time is of the essence in your contract, which you could be tested on, means that dates and deadlines are strictly enforced. If we put this as our date and deadline, that is our date and deadline. And we get it. Life happens. Life is busy, life is messy, things come up. Well, if something comes up, we're going to do an amendment to a contract. We're going to amend a date. All right. So let's say that you say tomorrow is the deadline, and we get to tomorrow and we still haven't done the things that we need to do. If both parties come together and say, hey, it's okay, we can extend this deadline, then we amend it because it's an amendment to a deadline that was already in place. Then we have acceptance. The offer grants the offeree the power of acceptance. So the seller gets this offer. All right. The seller gets the offer. They look it over. And so they say, hey, do I want all the terms? Like all the terms that have been listed in this contract, do I agree with them? Speak now or forever hold your peace. It has to be signed, and it must be communicated back to the offerer that it was signed and accepted. All right. So the buyer, the offerer, generally speaking, goes through and says, hey, I want to buy 123 Main Street. They put together the offer. They say, here are my dates, the deadlines. Here are all the additional provisions. Here's the money that I'm about to give to them for their home. Here's the type of loan I'm going to go out and get, what conventional, FHA, VA. The seller looks it over. The seller decides that they want to proceed. They proceed. They sign. We have offer and acceptance at this point. Now, let's talk about a counteroffer, because you're going to get some test questions on a counteroffer. And so when I'm looking at a counteroffer, when you change any term of an offer, now we're creating a counter, and the original offer is now void. It is now void. The original offer that you countered is no longer on the table. It is gone. At this point, the offeree now becomes the offerer. So now the seller is the offerer, and the original offerer, who was the buyer, is now the offeree, and they have the right to accept it or deny it. If the counter is accepted, we have a valid contract. All right. So we have a valid contract and we move forward and it looks just like any other contract. Now, this is what it looks like. A buyer submits an offer to purchase a home. The seller changes the expiration date of the offer by 1 day. They sign it and return it to the buyer. The original buyer's offer is now void. The seller has amended an offer as a counter offer, which the buyer can now either accept it or reject it. If the buyer accepts the counter, we have a binding contract. So for your test, I actually think you're going to get a question around a counter offer. And I think the question is going to be, what if your client wants to counter, what contract do they sign? Is essentially, right? We know it's multiple choice. So, but when we're looking at this, they're not going to sign the original offer. They're going to sign the counter, because if they sign the original offer, we now have offer and acceptance. You only sign the contract that you want to go under contract on. So the seller wants to counter. They sign their counter. They send their counter over to the buyer. If the buyer accepts, the buyer signs and we have offer and acceptance. If the buyer wants to counter the counter, they write a new counter. They sign counter 2 and they send it to the seller. They do not sign counter 1. All right. You only sign the offer you want to accept. Now we have expressed and implied contracts. An express contract is one which all the terms, all the covenants of the agreement have been stated and agreed upon. And an express contract can be verbal and it can be in writing. It could be either one. Both parties come together to say, like, this is the playground rules. This is my intentions. This is your intentions. Let's move forward. The parties explicitly define the rights, the duties, and the obligations of each party. Now, implied's a little bit different. All right. An implied contract is unstated. It could be unintentional. That's actually where I think it shows up the most, is this unintentional agreement. All right. Like we might think of, hey, Mr. and Mrs. Buyer, you guys want to go look at some houses? And they say, yeah, sure. Let's, and you jump in the car and you go look at houses and you're like, cool, we have an unstated agreement. Like they jumped into my car and they are now my clients. We'll talk about how it shows up the other way. The contract is formed by conduct, not explicit words when we're talking about an implied contract. So let's look at this thing. Let's talk about implied agency agreements, because this is where I think it shows up and it's detrimental. All right. A common example of an implied contract in real estate is the implied agency agreement. Okay, so we have implied that we are working for somebody, because an agency agreement is an employment contract. All right, it's an employment contract between a client and yourself. But now we have an implied contract. So an agent without a formal contract performs on behalf of a buyer. All right, so they're negotiating, they're doing some stuff. By taking these actions, the agent may have inadvertently created an implied contract with the buyer. Now, if the buyer compensates the agents for these services, the implied agency agreement, that's going to be even harder to dispute, right? Like there's no one's going to say no takesy backsies. You got paid, like you knew what you were doing. Even if it is unintended, the actions can create enforceable obligations. Now, this is where I can think it could show up interestly, right? Is if you're in a state that doesn't have dual agency. You're in a state that doesn't have dual agency and you are doing all these things for another party. You haven't clearly stated how you are representing them or if you are representing them. And now they think that you are their agent as well. And now you potentially have a conflict of interest. This is the adverse side of things, right? Like this is where this could show up and there could be some hot water that some agents are getting themselves into. Bilateral versus unilateral contracts. You're going to get some test questions around this. A bilateral contract It's an agreement where both parties make promises, right? It's an exchange for another party's performance, right? When we're going through, it's a promise for a promise, bilateral at two parties. So one of these, right, when we're thinking about this, is each party is actually bound to a performance metric. When we're going through, one party does something, the other party does something. That is bilateral. Let's think about the exclusive listing agreement, right? The broker promises to actively market the property, right? They're saying, hey, I'm going to put in the MLS. I'm going to put a sign in the yard. I am going to host open houses. I'm going to go door knock. I'm going to canvass the area. I'm going to do all the things. I'm going to put it on social media. They're going to try to sell the property. And if they are successful, the seller promises to compensate the broker. Hey, if you find me a ready and willing buyer that performs, I will pay you. That's a promise for a promise. We have a bilateral contract. Since both parties make enforceable promises, this is bilateral. Which brings us to this other side of things. We have a unilateral contract. All right. So a unilateral contract is just one party. One party makes a promise. Only if the other party chooses to perform. All right. So one party says, hey, this is what I'm doing. And the other party gets to choose how they want to play. So the second party is not obligated. All right. The second party is never obligated to perform, but the first party has to. They have to fulfill their promise, guys, because that's what a contract is. It's a promise to either do something or not to do something. That's all a contract is. So most of the times we think about these like buyout agreements, these options. All right. So we have an option. The optionor, the seller, promises to sell the property if the optionee, the buyer, decides to exercise the option. Now, the thing is, the buyer might need to go get the money. Maybe they say, hey, I need $600,000. It's not in my bank account. And I need like 45 days to go come up with that money. And the seller says, okay. Well, the optionee, the buyer, never, ever has to go find the money. And even if they do find the money, they never have to come back to the seller with the money. The seller, on the other hand, has to sell the house if the buyer brings the $600,000. Also, the seller has to wait that 45-day time period. So whatever they promise to do, they are obligated to perform their promise, whereas the buyer isn't. So when you're looking at this thing, when we're talking about the option and we're going through, I do think that that's going to be your test question. It's going to be an option contract. So if you do get a test question around what is an example of a unilateral contract, the answer is option. So you get that, divert to option. That is going to be your answer.